Good day, Internet. This is Chavez and Valko, the key to your immigration solutions. I am Senior Associate Ben Hamilton. Here with me, as always, is Associate Attorney Andrew Craven. Andrew, how's traffic this morning?
Terrible, but that's the how's your day been?
Well, hey, look, terrible traffic, I guess, means COVID's over, right? Um, Everyone's coming back to the office, apparently. I don't know. Anyway, when you see our smiling faces, we're here to talk about everything employment based immigration related. And we've been doing a series of videos covering all the different non immigrant visas and then immigrant visa categories. Again, you hear non immigrant, that's temporary immigrant residency. Um, and today we're going to be talking about the EB-5. So when you hear EB, right, that means employment based. So it's employment based first preference category, second preference category, third preference category, all the way up to EB-5. We've done videos on all the other ones employment related, and this is kind of our last in the series. And today we're going to be focusing on EB-5 direct investments. There's this whole other thing called EB-5 regional centers, which was just reauthorized. We're going to talk about that in a separate video because it's its own complex, complicated animal. Now, one thing I want to start out here and say, well, the EB-5 and you hear EB-5 and investment, not to be confused with the E2. The E2 is a non-immigrant visa. We have a video on that, and the qualifications are very different. If anything, they're much lower and easier to get. Whereas the EB-5 is a residence thing. Anyway, Andrew, let's jump into this. What is the EB-5 Immigrant Investor Program?
So this allows investors to apply for a green card if they have made the necessary investment in some commercial enterprise within the US and plan to create or in some cases preserve 10 permanent full-time jobs for qualified US workers.
Sometimes you hear about, oh, people are just, buying green cards. You go, well, I guess if that's how you want to frame it. But yes, you can invest money and use that as a basis to get a green card. Of course, why would we have this program? Well, because it brings in, well, has brought in hundreds of billions of dollars of foreign investment to the United States and created hundreds of thousands of jobs, right? A lot of people do not realize it's like, oh, that foreign national, he's just buying a green card. Hey, what do you do? Construction. Where do you work? On this big residential high rise over here. Yeah, you know that was like funded in part through EB-5 money. So yeah, that's how you got your job. But anyway, that's the idea behind the program. Bring in foreign investment, create jobs, people get green cards. Um, so how much do they have to invest in order to do this?
So we actually talked about how this went up recently. It's currently $1 million or sorry, $1,050,000, or in some cases, $800,000 for what's called targeted employment areas. Although last time I checked last night, USCIS has still not updated their website for these numbers.
Yeah. So the number change is, of course, fairly recent to when we're filming this video, right? Because Congress passed a reauthorization bill. Backtrack a little bit. EB-5 was created back in the 90s, right? Um, and there's been actually very little changes to it since then. After the direct investment program was created, they then added the regional center program. So the direct investment program is permanent. The regional center program is temporary and has to constantly be renewed. So they passed a bill recently to renew the regional center program, but that also included changes to the overall EB-5 program, including the amounts. So it used to be a million, now it's 1,050,000. That's just a weird number to have to say. Like, I don't know, 1.1 million would have made like roll off the tongue better than 1,050,000 or 800,000 in a target employment area, which used to be 500,000. Um, are these numbers going to be subject to change again?
Yes. So the amount's actually set to increase in January of 2027, and then every 5 years after that. And ultimately, the minimum investment is going to increase based on the consumer price index. And then for the targeted employment areas, it's just going to be 60% of whatever the standard investment is.
So we said that there's two different amounts, right? The standard is over 1 million, and then the targeted employment is 800,000. What is a targeted employment area?
So basically, rural areas or areas of high unemployment. Getting into the specifics, it's got to have at least 150% of the national unemployment rate, or the rural area is defined as a town or a city outside of a metropolitan statistical area with a population of no more than 20,000. And that's based on just kind of the recent census.
And of course, this recent bill made some tweaks to this, right, to try to drive more money into rural areas and also more money into infrastructure projects, which is something they kind of added um, to the targeted employment criteria. Um, so this is an area where there's a lot of active change going on to how it is viewed. And an important one is to who determines it, because who currently is authorized to determine what qualifies as a targeted employment area?
So previously it was, the actual municipalities and such, and now that's being currently shifted over to just the Department of Homeland Security.
Yeah, I mean, because obviously what Homeland Security didn't like is, a state has the incentive to designate everything as a targeted employment area as long as investment comes in, right? So you'd have a project in downtown Manhattan, and you're like, well, how's that a targeted employment area? Well, they gerrymander it with a bunch of other like counties or districts or areas until you kind of get to that number you want. And of course, USCIS is like, well, this seems to be defeating the purpose of the program because all of this money is going into downtown Los Angeles, downtown New York, like um, when they wanted it to go more to targeted employment, actual targeted employment, like I don't know, Detroit, or rural areas. So now the Department of Homeland Security said, no, 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 no more of this. States or local governments designated target employment areas. We're going to do it. Um, and obviously, it's one of these areas where we're still kind of waiting to see what the exact changes and fallout is going to be. Um, but again, if you're looking to where we are do a project in downtown Dallas, it's probably going to be a lot harder to get that designated as a TEA. Um, so, what are the requirements, the sort of the basic requirement of the business that you would be investing in?
So, one of the key ones is it has to be a business, right? Not a nonprofit, but it has to be a new commercial enterprise, which is one formed after November 29th, 1990, when the Immigration Act of 1990 was actually passed. But there are a few exceptions to that new requirement.
So, a common phrase, just when you're looking at EB-5 videos or literature or whatever, is you're going to see this word pop up that says NCE, right? New commercial enterprise. I mean, when you're talking about direct investments, that's usually the investment, what the actual business, right? So if you're like, hey, I'm forming this LLC and we're going to, like, I don't know, build a McDonald's franchise. I mean, it's usually a new commercial enterprise is that LLC you just formed. You're going to invest into and is going to go build that McDonald's franchise. Um, there obviously said there are some exceptions to the new requirement. Um, Usually around, if it's an older business that's being restructured or reorganized, is being expanded to increase the net worth or number of employees. So there are some exceptions. Now, again, a lot of times what happens is, you're looking at I can buy an existing business, or they say, "Oh, well, I'm not buying the LLC. I'm going to form my own LLC, but then buy an existing business under that. Was in my LLC a new commercial enterprise?" It's like, well, they're not that dumb, right? They're going to look at you're just buying existing business with existing employees, and are you really expanding that business and creating 10 additional jobs? Are you just preserving 10 jobs? So there's a lot of nuance that goes into this. Um, can the investor just sort of make the investment and then just be like hands off, like, cool, I put my money, now I'm just going to sit back and wait for my green card to roll in?
No, so the investor actually has to engage in the management of the enterprise. So going back to what you were saying before, this isn't as straightforward as just purchasing a green card. You actually have to be really involved in the management of this new commercial enterprise.
Yeah, and like again, we're talking about direct investment. Regional center investments are a little bit different in terms of how they interpret this sort of management participation. Um, but direct investments, right? You're typically looking at someone who's more involved. Again, you remember these exceptions to the new commercial enterprise, business formed after 1990 are, if you're buying something that's older that you're reorganizing or restructuring, and then that you're then expanding either through expanding the income, um, or like net worth by at least 40% or the number of employees by 40%. Those type of investments tend to be really rare, right? Most people are investing in like something new, like, oh, we're going to build a hotel, we're going to build a restaurant, like it's something that's new. So, talking about capital. So what qualifies, as investment?
So investment in this case means the contribution of equity capital. So loans of capital to the business are not do not qualify for EB-5 purposes. And the investor cannot receive any bond, note, or other debt arrangement from the business in exchange for that contribution of capital. Also, the investor's personal guarantee of a loan, it's the primary obligation of the business, doesn't count as equity investment capital.
So what are some of the things that, do count as capital?
So this can be cash, cash equivalents, equipment, inventory, or other tangible property, or secured promissory notes.
Um, Actually, I'm going to skip over some things here because they're out of order. But anyway, um, here's an interesting one. Can I combine investments in multiple enterprises?
So an investor can diversify across a portfolio of businesses or projects, but only if the minimum investment amount is first placed in a single new commercial enterprise that then diversifies the investment across businesses that it wholly owns. So you just kind of have
Yeah.
to structure it.
Yeah. So think of the NCE as like a holding company, and the money goes into that, and then it trickles down to wholly owned subsidiaries. And that's a key language there, wholly owned subsidiaries. So if I said, well, I'm actually going to do 3 restaurants, but I'm going to form a holding company, put the $1 million into the holding company, and then like, oh, 300,000 goes to this wholly owned subsidiary. It's going to do restaurant A, and then 300,000 to this one, and then 400,000 to that one. You can do it that way, right? Now, what they don't want to see is where you just check, like, where these 3 restaurants are separate LLCs, and I just go 300 here, 300 here, 400 here. They're like, well, no, that's not a single NCE, right? Those are 3 different businesses. That's not going to work. So you have to put them under like a holding company, and the holding company is the NCE essentially. Um, so now we're going to go to source and tracing of funds, source of funds. Okay, so now I'm going to jump back up here in terms of source of funds. Um, in general, what's the sort of basic requirement regarding someone's source of funds?
So the investor's source of investment capital has to be lawful, and the capital has to originate from the investor's personal funds.
I want to throw out one caveat here because a lot of people are like, "Oh, this is just a pay to play. Isn't there, a lot of fraud and guys getting through that shouldn't?" Blah blah blah. I'm saying, look, there is a lot of fraud in the EB-5 space, but it's not the investors, right? Most of the fraud is the EB-5 regional centers taking the investors' money and then screwing them over. That's why this bill we talked about that reauthorized the EB-5 regional center program, it did a bunch of changes that impacted the whole program, but the majority of the changes were focused on regional centers, right? And all of what and who can run a regional center and all the reporting requirements, because The most of the fraud in this space was regional centers taking advantage of investors. If you're worried about investors somehow getting through that shouldn't, don't. Because when it comes to EB-5 cases, USCIS is anal about source of funds. They are crazy about source of funds, right? And we're going to talk about this a little bit more in detail here, but this is where it is really hard to sneak something through here. It's really hard to like, oh yeah, my former life, I was a cartel boss, but I snuck it through and pulled one over and I got a green card when I shouldn't have. That is extremely rare. Now, so let's talk a little bit about a source of funds. Can a gift be a source of a fund?
Yes, so gifts are allowed by USCIS, but they will want to see the source of funds of the donors. So ultimately, your dad gives you $1 million to go invest. Well, that's fine, but now they've got to go back and look at how did your dad get the money?
Yep. What about loans? So I got a loan from a bank or really anyone.
So loans to the investor are allowed if they are personally and primarily liable, and the loan is secured by the investor's personal assets. So not the businesses, but the investor's assets.
Yeah, and so this has like been a really big one, right? So if let's say I own a home in my home country, I've been paying on it and I have a lot of equity, and then I go to the bank and I say, hey, I want to like refinance my house, pull out all this money, um, and then I use that as my investment. You can do that. Now you're gonna have to document all of this, right? And you're gonna have to prove that the basis, you're personally liable and that your collateral is personal collateral. In this case, it's your house, right? Where you can run into issues because sometimes this happens is if it's like, well, I go to the bank, me as an individual, and I say, I want a loan. They say, what's your collateral? My parents have a house. And they go, okay. Parents sign on, and then that's not going to work because that's not your personal asset. It's your parents' personal asset. Now, where there was this crazy issue that USCIS just one day decided out of the blue that they were going to go crazy is you imagine the scenario where the parents own a home. The parents get a loan based on the home and then gift that money to their child who makes the investment. So, in everybody's mind here, we're saying, well, what's the source of funds to the investor? Well, it's a gift, right? Makes sense. Shouldn't be an issue. And for a long time, there wasn't. And then just out of the blue, USCIS was like, started essentially denying these cases because they're always going to ask, well, where did the parents get the money? Right? They're always asked that. You say, well, the parents got it as a loan. And then they were saying, well, the parents got it as a loan, but that loan wasn't your asset. It was the parents' asset. And of course, you're like, what does that have to do with me? I got it as a gift. You're like confusing the two things here. Like, it doesn't matter if the person who gifted it to me got it as a loan that wasn't my collateral because that's anyway, there was a big class action lawsuit, and there was a big, I think it was around 2018, where USCIS got smacked down by the courts, basically saying, "Hey, your interpretation of this is completely wrong, right? Like, I don't understand how you're getting from A to B." The court said this, and then the court then also said, um, "Nor did you go through the proper channels to make this reality, right? If you really wanted to make this like reality, you should have gone through the Administrative Procedures Act to change the regulations, which they didn't do. So there was this whole period here where you had people, dozens and dozens of people doing something one way, and then suddenly getting denied with no forewarning from USCIS, and of course their legal reasoning was like batshit crazy. You're just like, what? Um, but the key here though is that you know if you do like say get it as a gift from somebody who got it as a loan, they're going to want to see all of that documentation. And here's the question, right, Andrew? So let's say I got it as a gift from my parents. They're going to want to know where the parents get it. And parents say, well, we had a house and we used the house to get the loan. What's the next question going to be?
I mean, I'd want all the documentation for how did you pay for the house, and I mean, the entire, all right, if you've been paying on that house for the last 20 years, I'm going to want to see that you were making money for the last 20 years from a lawful job, putting that equity into the house, and then pulled it out.
Exactly. So when we say like, "Oh, isn't there like a lot of fraud?" Nope. Um, Not in this context, right? Because they are so anal about it, right? I mean, they will say, if you don't submit this information, you'll get a request for evidence that says, "Okay, you got it as a gift from your parents who got the money from a loan or they mortgaged their house. Where did your parents, how did your parents buy the house?" Right? And they'll want to see. And again, like you said, sometimes this can be problematic because maybe they didn't buy the house in one go. Maybe they've been paying on the house for 30 years. And say, well, okay, well then we want to see that how are you paying on the house? Like, what was your job? And again, certain countries, these documents might not be available like 10, 15 years ago. There's also countries where like you don't pay personal taxes if you're just an employee. The company you work for pays all the taxes. So you don't file an individual tax return. So it can be sometimes difficult trying to cobble all of this together and prove this because again, just because you got a gift doesn't mean that's the end of the analysis. They're going to go, where'd the gifter get the money, right? And they can keep, uh, walking that back. Can I use escrow potentially as a way to like kind of protect myself?
Yes, so funds held in escrow until the investor obtains conditional residency is allowed just as long as the funds are immediately and irrevocably subject to release upon approval of the green card status, or sorry, their status essentially.
Yeah, so escrow can potentially work, right? But there can only be that one condition in terms of release of the funds, right? That it's just essentially approval of the conditional residency. So we kind of alluded to it a little bit, but let's kind of work through some of this in terms of, what are we having to document when we're document both the source of funds, but not just the source of funds, but also the path of funds, right? Because in terms of how did it get from point A to point B? Because if you're just like, hey, I sold a house, here's the purchase sell agreement, and then, hey, here's me investing the money in the NCE, right? They're going to come back and be like, yeah, we're missing some links in the chain. How did the money go from being over here to being over here? So, what are some of the things that we're going to have to document?
So first off, the investor's income tax returns, personal or business, for at least the last 5 years, their resume or CV, if applicable, any judgments or evidence of pending civil or criminal action involving monetary judgments against the investor, uh, detailed explanation and documentation regarding the actual source of the investment, capital such as employment earnings, stock sale, gift, loan proceeds, sale of real property, everything. If you're selling or mortgaging personal assets and using those proceeds, the proceeds of that transaction for the investment, then you need to provide evidence that the asset was purchased with lawfully obtained funds. Again, selling the house to pay for this business. All right, how did you pay for the house in the first place? Documentation of lawful origins of any funds facilitating transactions that yielded earnings. So, I mean, just about everything. Um, where the funds originated from. If it was a gift or a loan, you have to provide background documentation of the donor or lender to verify the lawfulness source of the funds. So again, well, if your parents sold their house to invest, all right, how did the parents get the money for the house and so on? And again, the actual path of the investment. So every bank transfer, wire transfer, checks, adjustments, the whole path.
Yes. So if I sell a house, right, they're going to want to know they're only not going to want to see the purchase sell agreement for the house. They're going to want to know where I got the money to buy the house in the first place. And then when I sell the house, I deposit it into my bank account, let's say in Mexico, and then I transfer it to my personal account in the US and they're going to want to see that statement, right? And then I transfer it to my savings account, which some people do, and then move it back to my checking account after I decide I change my mind and then invest it in the NCE. Like you have to document every single little chain of these funds, right? So that you can show um, like that you can basically this completed chain from when I got this legitimate funds to when they got through all my different accounts to the NCE. And this sometimes can be crazy because you can have people that are just moving money around, like, oh, I sold this thing and then I moved to this bank account. From this bank account, I put it into an actual investment fund. And then I took it out of the investment fund and put it in my savings. I took out my savings and I put it in my checking. And then for my checking, and you're like, oh my gosh. Well, cool. That's why flow charts are really important. Like you get all the documentation together, but at the top, you like literally will create flow charts. So like they can an officer reviewing it can at least visualize it, be like went from here to here to here to here to here to here. Here is exhibit A, here's exhibit B, here. And so they have this flow chart on top, and then they can go through and see everything. Andrew, have you heard of the EB-5 Friends and Family Plan?
No, no, I have not.
Do some countries have limits on the amount of money you can take out of the country?
Yes, definitely. And I've also heard that some countries will just, or you get flagged for transferring over a certain amount, which is why you would sometimes work with friends and family to, hey, everyone.
Well, let's just say you're in China, which historically had a limit of $50,000 per person per year, and you needed to invest $800,000. Man, I'm terrible at math, but how many people is that now? So
I
I
want
can
to say
send out
16.
that's 16 people. That means
Yeah.
I would take $50,000, send it to 16 different people, and they would and they to their like Chinese account, right? And then those 16 different people would either send it to my US account or maybe transfer to their US account and then send it to my US account. Of course, now you have to document this, right? You have to get affidavits from 16 different people, bank accounts from 16 different people, saying, "Hey, so and so transfer me this money for the purposes of sending it outside the US, and it went to this account of mine and then I transferred to this account of him, and it's really his money, right?" So there's the friends and family plan where I just like send it out and then it comes all back in. There's also the swap plan, right? Which is basically like, "Hey, I have an account in the US. You have an sorry, I have an account in China, you have an account in China. I have an account in the US, you have an account in the US. So, how about I send $1 million from my Chinese account to your Chinese account, and then you send $1 million from your US account to my US account." So it's kind of like this thing where it goes, whoop. It doesn't actually like connect, right? Because money never actually goes from your Chinese account or my Chinese account. Money never actually goes from China to the United States, right? I'm just transferring money from my China account to your China account, and then you from your US account to my US account, so we can get the money out. That type of stuff happens too. You got to document it, affidavits. It's fun when you're dealing with countries that have restrictions on this type of stuff, and then trying to document to USCIS that you are not a drug cartel kingpin, because that is what they assume everybody is. Um, so I can tell you right now, anybody considering EB-5, that is the number one thing. It doesn't, I mean, you can invest $1 million in this amazing hotel that's built and it's beautiful and I have pictures of it and it employs all these people, right? That sometimes can be the easiest part of the EB-5 is actually investing the money. Um, One of the hardest parts is documenting where the frick you got it, um, and how you moved it to the US. Again, depending on what country you're from, this is going to be the number one focus of any EB-5 case, especially direct investment cases. Okay, we can move on from that, I guess. Ooh. Now, the money has to be placed at risk. What does that mean?
So basically, just transferring funds into an account of the enterprise doesn't satisfy the at risk requirement. What they're ultimately going to focus on is the actual intended use of the capital and confirm that it'll be used for job creation or profit generating activity. So, capital used for partnership expenses and reserved accounts does not count for EB-5 purposes.
So the big thing here is that the money has to, for the most part, be spent. Or like we talked about, like escrow, right, with only one condition. But essentially, the money has to go into the account and be spent on something. Like I said, I'm going to build a hotel. Well, go build the hotel. Like you can't just be like, hey, I got $1 million. I don't know. I'm going to put it in the stock market, or I'm going to, I don't know, buy some real estate. If you develop the real estate, great. But if you're just like holding it, like, no, that's a passive investment. But there's this other really key thing that comes up in EB-5 investments that people sometimes overlook, and it's called a redemption agreement. What are redemption agreements? Why are these problematic?
So, a redemption agreement or promise to return any capital is kind of a common act in investment scenarios, but it's not allowed in EB-5 situations because it negates the element of the at risk, and therefore it's not an investment.
So let's just say I'm your average Joe, American citizen. Some guy comes to me and says, hey, you want to invest in my real estate project? I go, okay, but what is my security? Right? I give you $1 million. What is my security? And they say, well, you're going to be a part owner, and you're going to be, as a part owner, you're going to be entitled to a portion of the profits. And for EB-5 purposes, that type of thing's okay, right? To say, hey, you'll get, a portion of the proceeds. You're not guaranteed an amount of a certain, the proceeds will be a certain amount. It's just, hey, if you're own 20%, you'll get 20% of whatever the revenue is, which may be zero. That type of thing's okay. But a lot of times, again, if I'm a US citizen, I'm like, well, I need something more. So let's say, okay, well, we're building this apartment complex. If for some reason things kind of fall apart, you'll get one of the apartments, right? Or they'll try to like guarantee a return, not the percentage based on my ownership, but like the actual amount. Oh, we'll guarantee, you'll get 10,000 a month for 3 years, right? That type of stuff is normal in a lot of like these type of like deals. They are not allowed in EB-5. So that's where you have to be careful. When you're dealing with regional centers, right? They're experts and they know all this. But when you're dealing with direct investment, more often than not, you're dealing with people who are just used to doing real estate deals, but not in the EB-5 context. And so you can run into issues if you're not carefully reviewing all of the contracts and the agreements to make sure there's not something in there that's impermissible, right? Again, common ones are promising some type of like physical asset, like, hey, you get an apartment in this building, or like some type of guaranteed return. Again, if it's just like you own 20% and you'll get 20% of the profit, that's fine because the profit might be zero. We don't know. It could be a ton, it could be nothing. But if it's like a guaranteed amount, like, oh, 10,000, or if it was like a guaranteed like buyback, right? Oh, we'll buy this back in 2 years at $500,000, like a guaranteed buyback with a price and all that. That type of stuff, not allowed. Um, all right. Of course, we've talked a lot about how much you have to invest and what counts as an investment and how do you document your investment, right? Because we know there's two key components, right, to the EB-5. There's the investment and then there's the job creation. So we've mentioned that we have to create or preserve 10 jobs. When do the jobs have to actually come into existence?
So at the initial stage, the what's called the I-526, so your initial application, that state the investor has to demonstrate the jobs will be created in 2.5 years. Uh, Again, we talked kind of a little bit about this. They become a conditional resident. So when they go to remove those conditions, the I-829 state, the investor has to demonstrate that those jobs were actually created or can be expected to be created within a reasonable time, which is generally 3 years from receipt of the conditional residency.
A lot of times when you file your I-526, the jobs aren't in existence yet. So maybe you set up your NCE, right? You've invested the money, and let's say you're going to build a hotel. It may be that like you purchased the land and you've started construction when you file your I-526, but that's it, right? Now, you're going to have to include a very detailed business plan and a very detailed economic impact report, right? That's going to show, well, hey, when this is finally done, this hotel is going to have 30 full-time employees. right? But at the time you apply, the I-526, the business doesn't necessarily have to be like done, up and running, 10 full-time employees. Obviously, if just so it happens, great, but it's not a requirement, right? Because like you said, when the I-526 is approved, when you apply for residency, it's not permanent residency, it's conditional residency. That's good for 2 years. So you have to come back and apply to remove the conditions. So it's usually when you remove the conditions that they're like, okay, where are the jobs, right? But even then, you don't necessarily have to have them if you can prove that they will come into existence within a period of time. My suggestion always is on a direct EB-5 investment that when you file, by the time you file the I-829, you usually want to have the jobs, right? Just, hey, the hotel's built, right? It's now operational. Here are our W-2s, our 941s, our Texas workforce quarterlies, our payroll reports to show that those jobs exist, are fully in existence. But again, stuff happens. Like, for example, COVID could have happened, production or construction could have gotten delayed, opening the business could have gotten delayed. And it's not necessarily the end if by the time you file the I-829, maybe not all the jobs are there. But what counts as a qualifying employee? Can I just, any old person I hire?
So some of the restrictions are first off, it's got to be employees. Contractors don't count. They have to be full-time employees. They can be U.S. citizens, lawful or conditional permanent residents, asylees, refugees, but not non-immigrant workers. They also can't be the investor or immediate family members. So it can't be like your wife and kids.
So the kind of key here is that it needs to be U.S. citizens or LPRs, asylees, and refugees, right? So it can't be someone like on a work visa. Um, this is why it's really critical to be like, well, are you using E-Verify? Because we have a case of a guy that had an EB-5 denied, even though he had 100 like somewhere, I think it was like 70 employees, but the EB-5 was denied. Again, we didn't work on the original case because when they submitted all the employee documentation, USCIS ran all of the social security numbers and determined that a bunch of these people were not work authorized. And then they're like, hey, these ones aren't full time. These ones aren't work authorized. So of that 70, they cut it down to like 5. And they're like, nope, you only have 5 employees. You don't qualify. Done. Which sucks because he is paying 70 people. And as an employer, like, what is my obligation? My obligation is to complete a 9-9. What do I do when I complete a 9-9? Well, the employee has to present documents showing their work authorized, and I fill it out. Andrew, if the documents the employee presents to me appear facially valid, am I allowed to question them?
No, not per U.S. labor laws.
Am I allowed to request a different document?
No, not if the first one was facially valid. Again, per U.S. labor
So
laws.
it is very real, and that actually happened in this case to this client that he did nothing wrong, right? Because he had I-9s for all of these employees. Now, apparently the employees lied, but that's the employee, though, right? So it kind of sucks because on his from his perspective, he's like, okay, these people might not have ended up being work authorized. A, I didn't know about it, right? I completed the I-9. I did what I'm supposed to do as an employer, and B, I'm paying them. But USCIS is just, they're kind of stupid in this regard. I mean, to me, I think it's kind of stupid just to be like, well, yeah, but these don't qualify, and it's like, but I'm paying somebody. So it's like you have to be really careful in the EB-5 space to be like, are you going to use E-Verify? Are you going to hire some type of independent agency that does some of the payroll and some of the background verifications? Because you don't want to find out that you've spent all of this money and all of this time and then you don't qualify. Um, Also, a lot of times in the EB-5 context, you'll hear people refer to the job cushion. Andrew, do you know what this is?
I'm just gonna hazard a guess and say this is getting a couple more people than you actually need, not for the business, but more people than you need for the investment, the EB-5 program, and building yourself a nice cushion.
I would never invest in an EB-5 where the actual projected job creation was just 10. because so much could go wrong there. There's no margin for error. Like it's just I'm one short, right? And we see this especially a lot when it comes to regional centers, right? That we're going to talk about in a later video, because regional centers usually have a whole bunch of investors involved. So it could be like 30 investors. You don't want to see 30 investors, and then we're going to create 300 jobs. Like they want to see a job cushion of like 1.5 to 2 jobs per investor, so that they know they're safe. Which actually leads into our next question, is to say, well, what if I'm investing in this hotel? It actually costs $3 million. So me and my 2 buddies are each putting in $1 million. Well, 1,050,000 each. How many jobs does the business have to create?
It has to create 10 jobs for each investor. So, and each of those jobs has to qualify. So, still, one of the groups that we talked about, permanent resident, citizen, full time, all that good stuff. So, if you have your 3 friends are doing this, then you need at least 30 jobs.
And again, we talk about job cushion. I would never invest in something that was literally just 30. It would be more like 45 to 50, probably minimum. If there was three investors. I don't know what's 30 times 1.5. I'm terrible at math, but anyway, that's why I'm a lawyer, not an accountant.
Say
Or that's
45,
why
but that's
45. So you're looking at, like, hypothetically, you would want to see something if you had 3 investors that was going to create 45 jobs minimum, um, to be safe. Obviously, 30 is the actual minimum. But in terms of just risk you would want to take on, it would probably want to see a minimum of no more than 45. Um, so job creation can sometimes trip people up. Um, and like I said, the one good thing is that there's a lot more leeway in terms of time. So like right now, something like COVID, if you were filing your I-829 right now and you hadn't quite hit the 10 jobs yet, you'd still have enough leeway if you could like present like an updated business plan economic impact report to show that like, hey, within the next year or two, we'll get over 10, right? Especially since in this case, you'd actually have a external circumstance over which you have no control to kind of point to is the reason why. Um, but again, you got to be really careful because you're looking at, for example, restaurants, you're looking at like your back of house staff. You got to be really careful in terms of who you're hiring, right? Or like a hotel. Here's the other thing too. A lot of businesses, like let's say a hotel, would naturally outsource a lot of things, right? I mean, sometimes even like the maids that are in there cleaning the rooms come from an external agency, the groundskeeper, all that. And the EB-5, so they're like, oh, how many direct employees do you actually have? Under normal circumstances, it may be like 4, right? Just the people like, I don't know, working the front desk, right? And everyone else is external. Obviously, you're talking about EB-5. Now, all of a sudden, you have the incentive that all those people are going to need to be direct employees. All the maids, all the groundskeepers, like you want to hire them all as direct employees to get to the numbers you need. So we talked about this weird exception, or we've mentioned it, called a troubled business. So what is a troubled business?
So this is a business that's been in existence for at least 2 years and incurred a net loss for accounting purposes during either a 12 or 24-month period before the I-526 is filed. And the loss for that period has to be at least equal to 20% of the business's net worth before that loss. So that's all
Yeah.
kind of the details, but basically business is failing.
So why is this even a thing? Why do we even like why is troubled business even an option?
Well, it's treated differently in that if the investment is in a troubled business, then the jobs can be just maintained instead of actually created. And then you're showing instead of creating the 10 jobs over 2 years, that these jobs are being maintained for at least 2 years.
This would be kind of like because of COVID, there was this restaurant that's been failing, right? For 2 years, has a net loss, and the loss is equal to 20% of the net worth, right? So you see all these qualifications. I could hypothetically buy in a business that has 10 employees and qualify, right? Because I'm not actually creating new jobs, right? The idea is that I'm preserving or saving the jobs that are already existent. It's called, so this is like the troubled business exception. To be honest, it's something I see kind of come up very rarely because it's so nuanced. It's one of those things where it's like, do you really want to go down this very, very gray road with USCIS, or would you, or maybe it'd just be better to like invest in something new? But it is possible, right? If you do find a troubled business that qualifies to just buy it, not actually add jobs, just preserve the ones that are there. All right, so let's get into the nitty gritty of how you file for one of these things, right? So we've talked a lot about the requirements. So the filing steps and fees. So Andrew, I've made my investment. I got all my documents together. What do I do? What's step one?
So step one is ultimately going to be documenting everything, right? So you got everything together. You've actually now gone and invested the money. Then you're going to file the I-526 petition with USCIS.
And how much does that cost?
So that's going to cost the actual filing fee is $3,675. Again, we mentioned that new wall earlier. That's going to add a $1,000 fee that's allocated to what's called the Integrity Fund.
So 4,675,000 to file for an EB-5. Like I said, you're going to have to show, hey, here's the evidence that the business was incorporated. This is, our business plan, our economic impact report, everything that was, money's been spent on, to date. Hey, we bought the land, we started construction. Here's our bank accounts, all the money we have, and then of course all the source of funds. Hey, here's the transfer of all the money. This is where I got it from. Oh, I got it as a loan from a gift from my dad, who got it as a loan on a house, and documenting all that and going all the way back, putting it all together. Just so you know, I-526s are like sometimes this big. Like the hardest part of filing an I-526 is finding a box to put it in. I used to work at a firm way back in the day that the coffee that we had in our break room, the box it came in was like perfect. It was like paper sized and like this tall. I think it had like Folgers things in it. It was like the perfect. So we were always, hey, no, never throw away the coffee boxes. Never throw away the coffee boxes, right? Because it was like the perfect size to like put an I-526 in. I mean, these things are massive. How long are I-526s taking?
So I-526s are taking, let me just double check here,
We have a little flow
around,
chart we can put up. Where's our fun little oh, there we
yeah,
go.
so 47 to 71 months.
That is a long freaking time. Um, in part because, these things go to a special office in Washington D.C. They don't go to a regular service center like the Vermont, Texas. They go to one in D.C. where they have people like specially trained to do this. They actually have a whole bunch of like economists on staff and other people. Um, to review these things. Now, so step one is file your I-526 and wait 47 to 71 months. So what is step two? And we're going to talk here in just a second about how step two is actually kind of changed. So my I-526 is now approved. Am I automatically a resident?
No. So like a lot of other things with USCIS, you've got your initial petition, and this allows you to file your application to register as a permanent resident or adjust status. That's the I-485. Or if you're outside of the country, it's the DS-260.
DS-230 they have a special one for them.
Oh, 230. Right.
Yes. And of course, this takes a whole nother year, right? But Andrew, what was the big change? I would say in this law that was recently passed, there was a lot of changes that were like, oh, they're just codifying something they already do. There's no change. And other things that were changes that were no surprise, some good, some bad. Like I said, a lot of them aimed at curbing the fraud in the regional center program. But there was one big, I would say, positive change. And what was that?
So if you are current on the visa bulletin, then you can actually concurrently file the excuse me, I-526 and the I-485. So you can actually start working on getting your work authorization, travel authorization, all while you're starting the process.
And that's huge, right? Because you're looking up here, you may have to wait 71 months before you can even file for residency. But now, well, when I say now, the the implementation of the bill was 60 days or so after its passage. So it was in like May or what, I don't remember the exact date, but it was like in May, right?
Right.
Hypothetically, once the bill goes into effect, if you have an I-526 that's currently pending and you're legally in the US, I don't know, you're a student, you're an H, you just go ahead and file your 485. You don't need to wait for the I-526 to be approved. Or if you're getting ready to file your I-526, you can file your I-526 and your I-45 at the same time. Of course, that's huge because you have a lot of people. I've dealt with a lot of cases with people here, like as students, the parents give them the money, they invest it, but then how do I stay? Right. I mean, this is my long term solution to get a green card, but for the short term, what do I do? Like, I'm waiting 71 months. Well, a lot of them, they want to transition maybe from F to H, but of course, H is subject to just a random lottery. So, what happens if I never get selected? Um, Now, if I'm invalid status, and let's say my F's about to expire, I can file my I-485, which allows me to stay in the country. And then I'll eventually get a work authorization card and a travel authorization card. So not only can I stay, I can start working once I get that card. And then I can just keep renewing that card, the travel/work authorization card. I can just keep renewing that card every year until there's a decision. So if it takes him 71 months to adjudicate my I-526, which means it's also going to take 71 months to adjudicate my I-45, I can just keep filing renewals. So now instead of like whether or not me being allowed to stay is, I guess, dependent on me getting selected in the H-1B lottery, or maybe I'm here as already as an H, right? But H is cap out at 6 years. Or if I'm here as an L, that caps out at 7 years, right? You're looking at this processing time here, and I'm going to cap out, meaning I would have to return to my country because I just ran out of time. Now it's not going to be a problem, right? You'll be able to file your I-485, get your travel and work authorization. Now, again, we have two channels here. There's the in the U.S. channel, out of the U.S. channel. This doesn't really impact the out of the U.S. channel. If you're outside of the U.S., I mean, you still got to wait for the I-526. You still got to wait. It's a long process unless you're somehow able to come into the U.S. Now, when your I-485 is approved or your DS-230 and all that, and you go through the embassy, am I now a permanent resident? We're now 71 months into this process. Am I now a permanent resident?
No. So now you actually receive conditional permanent resident status, which means that 21 to 24 months later, you have to file what's called the I-829 petition to remove conditions on your residency. And that has a minor filing fee of $3,835.
Nothing, right? That's $3,800. Okay, that's a lot of money. But and we talked about how like the I-829, it's like the I-526, the focus is more on source of funds investment. A lot of the job creation is prospective based on business plans and economic impact reports. Whereas the I-829, they're more focused on like, how about the jobs actually created. And how long are these I-829s taking to be approved?
So that's taking about 44 to 68 months. But after that, you finally receive your permanent resident status, free of those conditions.
So before the change, you're looking at a 10 to 14 year process. That is really expensive. And you're going to get the worst anal exam you've ever gotten in your life when it comes to all of this stuff. I mean, it's insane. And it's super expensive. It is. This is why, believe me, we discourage clients away from EB-5 if we think they have another option, right? Because they're like, well, hey, I've invested $1 million. Yeah, but can you do a multinational manager? Like, do you have, did you have a business in your home country, and then you've done a business here that you've invested money in, right? Because we skip so many of these steps, right? We can take this 10 to 14 year process, cut it down to maybe 2 years. or maybe you can do an EB-2 national interest waiver. Like there's so many other potential avenues, especially like there are people that are from backlogged countries. Like, well, the backlogged country is mostly China, and it's mostly related to regional center cases. But believe me, I've talked to a number of clients that I've, said, yeah, could you do an EB-5? Probably, but is it practical? It depends, right? You have clients where there's no other option. So I guess we do have kind of a question here is about, we talked about, well, if I file my I-526, I can file my I-8485. And out of what status can I file my I-8485? Well, this is a little bit of some nuance here, right? So most people that are here on a non-immigrant visa. And Andrew, what do they mean by non-immigrant?
A non-immigrant visa basically means you're here for a temporary period, but a lot of those also come with the stipulation that you don't have immigrant intent. Yes, and that's what you're getting at.
Yeah. So all of them basically say your intent should be to leave. That if we at any time believe you have immigrant intent, we could use that as a basis to deny your visa or to deny your like entry to the United States. So a classic example would be like F visas for students and tourist visas, right? So when you go to apply for your tourist visa, if at any time they have any reason to believe that you're going to like want to immigrate to the United States, stay permanently, they'll deny it, right? So they look at things like, well, do you have family in the U.S.? Do you have family in your home country? Do you have ties to your home country? If they feel like you have no ties to your home country but family in the U.S., they're going to assume you have immigrant intent and deny the B, right? And then, of course, you can run, and even if they approve the B, you still have to arrive and go through CBP, and they can kind of do the same analysis. There are a couple exceptions, the main ones being the H and the L visa, which explicitly allow what they call dual intent. So if I go to apply for my H visa and the officer at the embassy asks me, hey, when you get to the US, or do you intend to apply for residency, right? You can say, hell yeah. Actually, it's already in the works, and then we're going to finish it the second I get there. Yeah, I'm applying for residency. Not a problem. If you're an H or an L, not a problem. You can totally say that. If you say that if you're a tourist or a student, denied. Get out of here. But USCIS is generally held to a 90-day rule. What do I mean by this? It means that when I enter as a tourist, I have to express tourist intent. But after 90 days, I'm allowed to change my mind, right? That's been the general rule. Now, I know someone's going to look at someone who's another attorney may look at this video and be like, oh, but USCIS removed the 90-day rule from their policy manual. True, but they also haven't replaced it with anything. And that 90-day rule actually comes from the Department of State, who still has it in effect. But generally speaking, if someone enters, let's say, as a student and then wants to file for residency, they're not prohibited from doing it. But if you file under 90 days after arriving, USCIS can say, well, you lied when you applied for entry. Because when you applied for entry, you said you were applying as a student or a tourist, and then you immediately filed for residency. So we don't think you have a lawful entry because you lied when you entered. But as long as you wait 90 days, generally, you're clear. You can see, right? They don't say anything. Because they say, well, yeah, when I entered, I entered truly intended to enter as a tourist, but enough time has passed for me to have, quote, changed my mind, and then to file for residency. So can you file for residency if their current status is like a tourist or a student? Yes. But you should always wait at minimum 90 days from your last entry before you do that, just to be safe. So it is possible. We hear a lot of confusion where people are like, you can't. Oh, I'm a TN. TNs can't have immigrant intent, so I have to swap to H. I have to swap to H. It's like, no, you actually don't. You can file for residency being a TN. We do it all the time. We just have to be a little bit more careful about the timing of certain things, but it's fine. You can do it. Now, you're going to want to be careful because you don't want to be entering the United States on a tourist visa with the I-526 already in the system, right? Because CBP could see that. And CBP could just be like, nah, You can have tickets to Disneyland and scream up and down, "No, I'm a tourist, I'm a tourist, I'm a tourist." But if CBP sees that I-526 in the system, they could just say no. Same thing for the Department of State, right? And you go to apply for a visa. If you need to actually apply for the visa and the I-526 is already in the system, they could say no. It's kind of hard to get around that unless you can really show, oh, no, 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 I have businesses in my home country. I have family. I have all of these ties. I'm really just going for this like short thing. Um, Also, there's the issue of where are you from, right? Because if you're from a visa waiver program country, you got the enters on ESTA, right? These are the people that don't need visas to come as a tourist. It's like a lot of Europe, some parts of Asia. Well, when it comes south of the border, it's just Chile, nobody else. I don't know why, but we get along with Chileans. Um, ESTA people that enter on ESTA are prohibited from filing for residency. That's like, hey, the good is you don't need a visa. The downside is you only get 90 days instead of 6 months, and you can't file a change of status or adjustment of status. Um, so if you're entering on an actual tourist visa, I guess hypothetically it's possible. Of course, we always try to look for if there's a way that we can maybe mitigate that risk. I don't really want to enter as a tourist and file an adjustment of status, but hey, as long as the client's aware of the risk, aware of the steps they need to take to mitigate that risk, just wait, then I guess you can technically do it. Anyway, Andrew, EB-5, this is a complicated beast. And we've only talked about the least complicated part of it, which is the direct investment. Hey, $1 million or less if it's a target employment area, create 10 jobs. There's a lot of nuance about where you got the money from, right? Documenting the source of funds. But hey, if you're interested in an EB-5, let us know, right? And then tune into our next video, which is going to be regional centers, even more complex. But hey, if you have any questions about non-immigrant visas, immigrant visas, whether it be EB-5 or something else, go to our website. You can schedule a consultation. You can reach out to us on social media. We're always here to answer as many questions, to try to give as much guidance as we can. Download our app, Law Pilot Guardian. It's on Android or iOS. It is a free app with lots of useful tools and information. But until then, hey, if you've tuned in and watched this whole hour-long video, thank you. And keep your eye out for the rest of our content. And hey, look, if you have any suggestions about future content, throw it out there, right? We've done all the visas, we've done all the residency categories, and now we're looking for other stuff, simple things of like, hey, how do I actually apply for a visa at a US consulate? I'm sure we're going to do a video just walking through that whole process, right? So, hey, if you have any suggestions, we're open, things you want to know about. But until then, Andrew, thank you as always for being along for this ride. Also, thank you, Joe, in the background, making all the video magic happen. But until then, thank you, and we'll see you later.